Hey everybody, happy Tuesday. Had a lot of rain. Let me dump my gum.
Why do you need cold?
What? What do I want?
Nothing.
Let me start over. Hey everybody, happy Tuesday. Hope everybody had a good day. It's been pretty wet down here. It rained really hard. At about 1 o'clock, I had a delivery of a 120 gallon water pressure tank from my well. And when the guy started unloading the truck, it was just kind of misting, not that big of a deal. But then we unloaded it, got it in the truck, started raining a little harder. Then he started fiddle farting around looking for his way bill, his bill of lading, I guess, to have me sign it that I'd received it. And while he was fumbling around looking for that, this just massive rain dump came. And in the 2 minutes I was standing there waiting, I got completely and totally soaked to the bone. It was crazy. Anyway, enough of my woes. Happy Tuesday evening. Tonight we're going to see Volume 1, Part 3 of Karen Wagner. Afterwards, I'll be answering some questions. I may pause as we're going through it, answer questions in line or verbally during the video. But to the extent that I don't get to all of them, we will be here afterwards to answer some questions. For those of you... What? What?
There you go.
Oh, sorry.
Turn that off.
All right, sorry. For those of... That was James's fault because he set it up and he didn't put it back on the mini mode. So that's not on me. Anyway, for those of you who are Patreon subscribers, exciting news. I know that there's already been a whole bunch of stuff up there, but now we have a bunch of more stuff. James has informed me that he loaded up the first 100 docket entries for NL versus Children's Hospital Los Angeles. That's a pretty cool case, very cutting edge what we did there. So that's probably worth a look. There are no depositions really in that case, though, because it was all litigated on the papers and through written discovery. So at some point, we'll get that up there next. James is still redacting things in documents in NL. I presume in NL.
I need to make sure there's no names mentioned. It's just NL.
Okay, right now he's just working on NL, but right behind that, he'll have the full public docket, I believe, for AA versus County Riverside.
Yeah.
And that's going to take some time. That was a heavily litigated case and went on for years. So there's a lot of material to go through there. But he'll be working on that once he finishes NL. But he is protesting that he has school now, so he has homework to contend with as well as class time. So the data flow, the bandwidth going up onto Patreon and probably even here is going to be somewhat diminished due to competition with school requirements and obligations. The next part of my Torts 101 section in Patreon will be uploaded sometime this week, but take special note that the week ends on Sunday evening at midnight. So I have time.
It ends Saturday evening at 11:59 p.m.
Well, that's according to you.
That's
anyway,
according to school standards as well.
Yeah, well, I'm not in school. Anyway, if you'd like to get caught up or explore my channel pages, do that. There's all kinds of stuff up there. One thing that happened that was really bizarre over the weekend, it was on Sunday, is James had uploaded the combined volumes 1 and 2 of Matthew Miller.
Like 1 in the morning.
At like 1 in the morning. And it got... by Sunday evening, it had 2,200 views. So that was kind of crazy. I don't really even know or understand where that came from. But anyway, I found it interesting. I thought I'd share it with you guys. If you develop questions as we're going through this or any other video that you watch on the channel, you can send those questions to capsandstemslaw@gmail.com, and we'll try to address them during the Sunday Q&A session that we do live Sunday at 6 p.m.
Yep.
Yeah, every Sunday at 6 p.m. we try to do that unless we have something else going on. Just remember in your questions, nothing case specific. We're not here to give legal advice. It's educational purely. So make sure that your questions are general in nature so that the answers would benefit, everybody in the group. With respect to Patreon, if you want to get on Patreon to get access to the work products, things you can use as templates, stuff like that, I've just posted the Patreon link in the chat. Also, the Patreon link is available on the little announcement thing that you saw on YouTube or wherever you got the information about tonight's broadcast. So with that, we'll get going on Volume 1, Part 3 of Karen Wagner. It's about 27 minutes long. Remember, I'm not providing legal advice or legal counsel. It's content to learn from for the entire group, including me. I learn something every single time we go through one of these things, so we're learning together. And a Joe Biden moment for me. I'm going to read the comment that's not intended to be read. It says, pause the talk and keep the audience engaged.
Why?
Just because it's a Joe Biden thing, man. And we all love and support Joe Biden. Right?
Stop.
Stop what?
Just stop with the jokes.
It's not a joke. It's serious. Anyway, here we go.
Have you ever been taught in any of your trainings from core to today that in order to remove a child from the custody of its parents, you must have reasonable and articulable evidence to show the child is in immediate danger of sustaining severe bodily injury or death in the time it would take to obtain a warrant? Have you ever been taught that or anything like it?
In obtaining a warrant?
Can I have the question reread, please?
Have you ever been taught in any of your trainings from core to today that in order to remove a child from the custody of its parents, you must have reasonable and articulable evidence to show the child is in immediate danger of sustaining severe bodily injury or death in the time it would take to obtain a warrant? Have you ever been taught that or anything like it?
To obtain a warrant, no.
Have you ever yourself in your entire career with the state of Arizona sought a warrant to
No.
remove a child?
No.
So I guess it would follow then that you've never obtained one either, right?
Correct.
Has anybody ever instructed you, whether it be a supervisor, a trainer, a teacher at one of these courses that you took, has anybody ever advised you that it is impermissible to remove a child from the custody of its parents unless there is evidence to suggest that child is in immediate danger of sustaining severe bodily injury or death?
Can you repeat the question?
Has anybody ever instructed you, whether it be a supervisor, a trainer, a teacher, at one of these courses that you took, has anybody ever advised you that it is impermissible to remove a child from the custody of its parents unless there is evidence to suggest that child is in immediate danger of sustaining severe bodily injury or death?
Yes.
Okay, when did that happen? The training. You're referencing some training, right? When was that training?
During core?
During core. And what did they teach you during core about how it's impermissible to remove a child from the custody of its parents without getting a warrant unless the child's in immediate danger of suffering severe bodily injury or death? What did they teach you?
Overly broad, vague, go ahead.
I'm not sure I understand what impermissible means.
Well, you can't do it.
Okay.
You can't do it without a warrant. You can't remove a child without a warrant unless you've got evidence to show that child is likely to suffer severe bodily injury or death in the time it would take you to get a warrant. That's what I mean. So what did they teach you in your core training relative to that concept?
Overly broad, go ahead.
Can you repeat the specific question?
You can't do it without a warrant. You can't remove a child without a warrant unless you've got evidence to show that child is likely to suffer severe bodily injury or death in the time it would take for you to get a warrant. That's what I mean. So what did they teach you in your core training relevant to that concept?
Can you rephrase the question?
I'm not really sure how I can. I mean, you've already told me that in your core training, you learned something about this concept, right?
Yes.
Okay. What did you learn?
We don't obtain warrants.
You don't obtain warrants. And they specifically told you that in your core training? You guys don't need to obtain warrants?
Object to form, misstates her testimony and vague, and I think also argumentative at this point. Go ahead.
Oh, wait a minute. If I'm misstating what you're trying to express to me, I absolutely don't want to do that. I really want to understand. So if I'm misstating something, jump up and down, make a big deal, tell me that, and we'll try to fix it. That being said, can I have the question reread, please?
You don't obtain warrants, and they specifically told you that in your core training. You guys don't need to obtain warrants.
Correct, we do not obtain warrants.
Okay. Did they tell you that anywhere else other than core training?
Standard practice in our department, we do not obtain warrants.
What do you mean standard? You mean it's standard practice in your department not to obtain warrants?
Yes, we do not obtain warrants.
And what do you mean when you say standard practice?
I'm not aware of any time any caseworker has ever got a warrant to remove a child.
And you're also not aware of any time that any caseworker has ever been told by a supervisor or a trainer or someone in authority within your agency, hey, we need to get warrants unless the kids are in immediate danger of severe bodily injury.
Object form, misstates prior testimony. Go ahead.
Again, correct me if I'm misunderstanding or misstating anything. Can I get the question reread, please?
And you're also not aware of any time that any caseworker has ever been told by a supervisor or a trainer or someone in authority within your agency, hey, we need to get warrants unless the kids are in immediate danger of severe bodily injury.
No, I can't speak for anybody else.
Okay, you've never heard it.
No.
And as a supervisor now, you've never told your subordinates that, hey, you guys, or some words to the effect, hey, you guys, we need to get a warrant to remove these kids unless they're in immediate danger of sustaining severe bodily injury or death. You yourself have never told your subordinates that.
Correct.
And one of the reasons that you've never told your subordinates that is because as a matter of practice and policy in your agency, your position is you don't need a warrant, right?
Object form, incomplete hypothetical, misstates various testimony. And also, in this particular case, it's argumentative. Go ahead.
And again, if I'm misstating anything, explain to me where I'm wrong. I mean, I need to know this stuff.
Overly,
But can I, go ahead.
just overly broad. I mean, answer whatever questions he has after I've made my objection. If he's got another question, then he'll ask it and we'll object or whatever. Don't correct him or whatever. Just answer his questions.
Did I misstate your testimony in any way? There's a question.
Object form, go ahead, if you recall.
No, not that I know of.
Thank you. Can I have the original question reread, please?
And one of the reasons you've never told your subordinates that is because, as a matter of practice and policy in your agency, your position is you don't need a warrant, right?
No, we do not need a warrant.
Okay, ever.
Object form, go ahead.
Not that I'm aware of.
Okay. Just make sure I'm clear on this, because when I say ever, yeah, I agree, that's a little bit broad. Might even be vague and ambiguous. I'm not sure I understood it. Let me just clear it up. Am I correct that, at least with respect to your understanding as a supervisor within the agency, there are no circumstances under which one of your investigators would ever need to get a warrant to remove a child from the custody of its parents?
Not that I'm aware of.
Okay, so I'm correct in that statement.
That we do not obtain a warrant.
Can I have the question reread, please?
Am I correct that at least with respect to your understanding as a supervisor within the agency, there are no circumstances under which one of your investigators would ever need to get a warrant to remove a child from the custody of its parents?
Is that a correct statement?
Yes, not that I'm aware of.
You guys mind if we take a quick break? I've been sort of plowing
Okay.
through these. Okay, going back to the case notes you were talking about a little bit earlier, and that's the CSRA, correct?
Yes.
And I think you told me, and again, correct me if I'm wrong in any respect on this, but I think you told me that when you're looking at verifying the accuracy of the court report, you look at the CSRA case notes to make sure that the information is the same. Is that right?
Objective form misstates testimony. I'll go ahead and answer you. It's also, I guess, it's vague and compound, I guess. Go ahead and.
Didn't need the question.
Okay, somebody raised the question, what does objective form mean? And I responded in the chat string here that they're basically objecting to the form of the question, like it's vague, it's ambiguous, it's vague as to time, compound, either in the disjunctive or the conjunctive. That's generally what it means, is that there's something wrong with the form of the question that renders it either unintelligible or subject to more than one interpretation. So one thing that the reason I paused here to comment on that is that one thing Jim Bowen just did, he did the proper objection. In Arizona, you're only supposed to object as to the form of the question by saying the phrase object to form. All other objections are preserved, so they do not need to be made or do not need to be asserted at the depot. He's been doing that, no doubt, just to coach his witness or interfere with the flow or screw things up, confuse her, confuse me. That's a common defense tactic. Actually, it's a common everybody tactic. I do the same thing when the other side is deposing my people, so I can't really bitch at them too much about that. That's like the pot calling the kettle black. But in this instance, the reason I interjected is because Bowen did the correct thing. He said objection form, but then he continued on and just sort of gave the definition of objection form as a string of further objections. You heard him say it's vague, it's overbroad. He might even have said compound. Completely unnecessary and improper. He should have just said objection form. That's the end of it. Move on. I'm not sure if that is helpful or anything, but I found it an interesting tactic.
Yes. Go ahead.
And I think you told me, again, correct me if I'm wrong in any respect on this, but I think you told me that when you're looking at verifying the accuracy of the court report, you look at the CSRA case notes to make sure the information is the same. Is that right?
I review the CSRA and the court report to make sure that the allegations in the petition are in there.
And we talked about this a little bit earlier, but that court report, that's a document that it's important that it's truthful, honest, accurate, and complete, because it's going to get filed with the court and a judge is going to rely on it in making decisions.
Yes.
Okay. The information in the CSRA does not itself get filed with the court, right? You don't like run a report from CSRA and file that with the court.
That's correct.
But what might happen is the investigator drafting the report might review the CSRA and take information from the CSRA and insert that into the report, correct?
They
Well,
may.
speculation, go ahead.
Yes.
They may.
Okay, and in fact, you've done that in your time before you became a supervisor, you yourself have done that, where you went into the CRA, took the information that you might have put in there as part of your investigation, and put that in your court report.
Yes,
Okay. Am I correct then that it is also, for the same reasons, it is also critically important that the information the investigator inserts into the CSRA case notes is also truthful, honest, accurate, and complete?
Compound, go ahead.
yes.
Okay. And when we say complete, what does that mean?
Vague, go.
I'm not sure I understand what you're asking.
Okay, you just testified that it's important, in fact critically important, that the investigator insert into their case notes information that's truthful, honest, accurate, and complete. Okay, we just talked about that. What I'm wondering is, in your concept, what do we mean when we say it has to be complete?
For investigations, it is the information that you have at the time.
Information you have at the time. That's all information that you have at the time, right?
Yes,
We can't leave things out.
correct.
We can't cherry pick.
Object to form.
You know what cherry pick means, right?
Vague, go ahead.
Yes.
Okay. What does it mean to you?
When you specifically pick something out of a paragraph and don't include the rest of it.
Okay. So when we're putting information into the CSRA case notes, it's inappropriate to cherry pick which information goes there, correct?
Vague assumes facts, go ahead.
Not all the information is relevant. How do I explain this? There is some information in your CSRA that may not need to go into the court report. So you may pick some statements out of there.
Okay, hold on a second, because we'll get to the court report eventually, but you're jumping ahead. I'm focused right now on the case notes, the CSRA case notes, and what goes into the case notes, not what we're going to take from the case notes and put in the court report. Are you with me?
Mm-hmm.
Okay. So focusing just on the CSRA case notes, it would be inappropriate for the investigator to cherry pick information she obtained in her investigation and only put certain information into the CSRA case notes, correct?
Object to form misstates testimony, in this case, requests speculation, and vague. Go ahead and answer that.
Can I get the question reread, please? And again, if I'm misstating something, tell us.
Okay, so focusing just on the CSRA case notes, it would be inappropriate for the investigator to cherry pick information she obtained in her investigation and only put certain information into the CSRA case notes, correct?
Can we go for the record just for a second? Maybe we can solve some of the confusion.
Sure.
Okay, you keep saying,
Off the record at 12 o'clock.
sorry.
Back on the record at 12:01.
All right, off the record, we had a discussion. You didn't participate, but you were sitting here listening as your attorney and I were discussing the distinction, if one exists, between case notes and CSRA. Did you follow that conversation?
Yes.
Okay, can you describe for us and perhaps clear up my misunderstanding regarding what CSRA is?
It is a summary of your case, areas that you document. I can give you an idea. So we document prior history with the family, if any, criminal backgrounds, any court orders, family court orders. Then source, who the source is. Children interviewed, parents interviewed, collateral. And then we do a summary at the end in regards to specific questions, your assessment. And then that's your CSRA.
Okay.
If you want to do a case note is a separate entry where you would type your note.
Okay.
So if you sent, just for instance, you received a copy of a police report, that's where you would document it in your case note.
Okay, so it may not, just make sure I understand, CSRA, it sounds like, and correct me if I'm wrong, that it's a narrative summary of what's going on in the case.
Yes.
Okay, so it's not an overarching database where all this information is stored.
Yes.
Okay. Is there such a database? Is there a database available to you where all of your investigative information is stored and accessible to the agency? If you know, you may not know.
I don't. I'm not sure I understand what you're asking specifically.
Okay, when you sit down in front of your computer to type this stuff up, is there a program that you have to load?
Load? No.
Okay, is there a program running on your machine?
Yes.
What's that program called?
Child's?
That's it, just Child's?
Is that yes? You should.
Yes. Sorry.
Okay, and when you're sitting in front of your computer screen and you have the program Child's up, describe for me generally what that looks like. Is it like a graphic user interface where there's buttons and drop-down menus and stuff you can go through and click on and do different things?
No, there are no drop downs.
Okay, are there radio buttons or buttons that you can click for different functions?
No.
What does it look like? Describe it for me. I'm looking at the screen. What do I see?
You're looking at a screen, and yes, I guess there are buttons at the top that will get you to your narrative, or you can search for a case. And there is a specific tab for the CSRA.
Got it. Okay, that makes sense. And is there also a specific tab for case notes?
Yes. Yes.
Okay. I will never again call it the CSRA case notes, and if I do, slap me. I'll have my permission to do that. Now, I don't remember what the original question was that got us off on this. Give me a second. With respect to case notes, when I'm putting together, as an investigator, putting together one of my court reports, and I think we covered this a little bit, I might go back, look at what is in the case notes with respect to interviewing witnesses, what they said, that sort of thing, right?
I want to make sure you and I are talking about the same thing.
Yes, please.
So a case note is different than your CSRA. Your CSRA has your documentation through the case, and it is a narrative form. Your case note is also a narrative. However, it may be ancillary stuff that's happened on the case that is not, maybe could or could not be factual. Maybe that's not the right word.
Important or relevant.
Maybe not so relevant. Like I said, if you got a copy of a police report, that's where you're going to document of the date and time that you received it, what agency you received it of, and the case number.
In the case notes?
In a case note.
Okay. What would you then do with that information in respect to the CSRA, the summary narrative?
When a case is either closed or closed at the investigative point and it goes on to another unit for services. Anything you have after that, your CSRA is basically locked down. And then everything after that is going to go into a case note. So any contact you've had with a child, with a parent, that is now going into a case note because it is not an investigation, it's
Now a
information.
case.
Right.
Okay.
Your CSRA is your investigation. And
Okay. So it's like an investigation narrative, basically telling the reader this is what we were called out to investigate, this is who it was, this is what we did, this is who we talked to, this is what we found,
Yes,
and then you'll have a conclusion of some sort at the end of the narrative.
yes,
Okay. Out there, in California, we call that the investigation narrative.
okay,
Then the case notes would be basically a record of all the contacts you made in the case with various different people, when it happened, who it was with, who made the contact perhaps, if it wasn't the investigator, right?
yes,
And then what transpired during that concept or contact, what somebody would have said or done, that sort of thing.
yes,
And all that's in the case note.
yes,
Okay. We call that the same thing out there. It's either the case notes or the delivered service logs, same sort of thing, just different name. Okay, am I correct that as a case progresses through your system, at varying stages, there's different agency staff involved in the case?
yes,
Some of those staff would include, obviously, the hotline screener, right?
yes,
Then we would have a supervisor who's going to assign the priority.
no, they do not assign the priority, that's assigned at the hotline.
Okay, let me back up. We have just at the hotline unit, we've got a hotline screener that's going to take the call.
Yes,
Then we've got a supervisor in the hotline unit who's going to review the screener's narrative and assign a priority.
yes,
Then the referral's going to get passed over to investigations, and a supervisor there will look it over and do the triage and then figure out which investigator to assign the case to.
yes,
Okay. And then at some point after the investigation is done, and let's assume that we've filed a court case with respect to the child, what happens with the case? Does it go off to a different worker? What happens?
yes, it's assigned to what we call an ongoing worker.
Ongoing worker.
Is that yes? I'm sorry.
Yes, I'm sorry.
And the ongoing worker, do you guys refer that to, do you refer to them at all as a case carrying worker?
No,
Okay, so they're the ongoing worker, that's it. At what point in time does the ongoing worker pick up the case?
it varies.
Generally speaking, when does that happen? At what stage?
It varies.
Okay, so there's no set
No.
time. Okay, we file a petition. That's done by the AG's office after the investigating worker signs the affidavit, right? That's the petition.
Can you reread that?
Okay, so we file a petition. That's done by the AG's office after the investigative worker signs the affidavit, right? That's the petition.
The petition is drafted, it goes to the AG reviews it, adds the allegations to it, comes back, the case manager reads it, corrects it if necessary. If there are no changes needed, then it is signed with a verification with an affidavit.
You said the case manager reads it and corrects it? Is that the same person as the investigator?
Yes,
Okay,
sorry.
so the investigator who's been assigned the case reads it, reviews it, if changes or corrections are needed, makes those changes and corrections, then signs the affidavit.
Yes,
Okay. Then the same person, the investigator, drafts up their initial report, right? What do we call that thing? Their preliminary protective hearing report.
yes,
Okay. Those get filed with the court to open a court case, right?
to open a court case, no.
Okay, well, do you at least have to file the petition to open a court case?
The petition opens the court case.
Okay, and then some point after the petition, you file the preliminary protective hearing report.
Yes,
That's done by the same person, the investigator.
yes,
Okay. Does the investigator then actually go and appear in court?
yes,
Okay. And depending on what the court does, an ongoing worker may or may not get assigned to the case. Is that right?
If you're depending on the court, yes, that could be possible.
Okay, so for example, in a case that gets dismissed, say the court says, yeah, there's nothing here, dismiss the case. We wouldn't get an ongoing worker because the case is dismissed, right?
Correct,
And it'd just be over.
yes.
Okay. If the court says, oh, yeah, hey, there's something here, we need to investigate further, have a full hearing, and perhaps a trial, in that circumstance, would you get an ongoing worker?
Yes,
Assumes facts, I'm sorry. Go ahead.
And your answer was?
yes.
Okay.
All right. I got to tell you guys, listening to that woman again brought back memories, and I've got this massive headache pounding. I maintain my calm so well with this. I'm actually impressed with myself. I'm going to pat myself on the back. But yeah, that was tough. Oh my God. So let's get right to the questions. We've got Sylvia Ann Ausweger. I hope I pronounced that correctly. First question, police
You
detain.
just skipped the Patreon question.
Oh, did I? Oh shit, you're right. I'm sorry. Patreon gets priority. Truth Schofield, Patreon question. Sorry about that. First question is, what is the best case law to argue against the time bar in federal court? I'm assuming you mean the statute of limitations. Now, that's going to be a tricky one because, you know, for most of the stuff that we do, God, and I posted something the other day to the chat. Hold on a second. Let me find it again. I might be able to give it back to you because although it's not directly on point, it's relevant to the question if I can find it. So give me 1 second here. Here, I think this one. No, that's not it. Shoot. Well, I'm going to have to look around. I'll have to look around and find it again. But basically what the idea was is that if there's a cover-up such that you would not have known that your rights were violated, you would not have known the facts that gave rise to the violation of your rights, then, you know, arguably you can, you know, get around the statute of limitations, the time bar. But those are really tough, few and far between. But the thing I was looking for is I found a case the other day. It was a wrongful death civil rights case where the police had covered up the true circumstances of the shooting such that the survivors, the heirs, were unaware that the decedent's rights had been violated. And in that case, the court had found two things. One, that, yeah, the statutory bar, the statute of limitations is blown out and begins to run from the time the family discovers the true cause. Secondarily, the court also found that it's a violation of the surviving family's constitutional rights for the cop to have hid evidence of his wrongdoing. So just hiding evidence that deprives the family of their day in court, you know, because of the time bar, was itself a violation. So that's something that you might research further and look at. And I'll try to find the case again. I'm trying to remember because I sent it to somebody and I thought I posted it here. Maybe I didn't, but we no longer publish the chats with the video, so you won't be able to go back and look through there. You might be able to find them on Facebook in one of the groups there, because I think those comments survive, but not the ones in the video. Second question is, how is being pro se helpful in arguing against time bar in federal court in the Ninth Circuit? The fact of your pro se status is not helpful in that circumstance. What the only time that being a pro se really comes into play is at the inception of the case, and that's the motion to dismiss phase. Yeah, motion to dismiss phase. Under Rule 12b-6, the federal district court has to bend over backwards to help you figure out whether or not you have a claim, what the claim is, and give you tons and tons and tons of leeway to get your pleading right. Once you're past that point, you don't really get any further deference at all. So, I mean, that may be a big advantage, especially on a cutting edge case. But once you're over that hurdle, it's no longer a tremendous advantage. Okay, question from Caps and Stems, Sylvia Ann Auswiger. And again, I hope I pronounced that right. I'm just sort of sounding it out. First question, please detain the child without a warrant. What, if any, documents are required by law to be given to the parent? Well, if they detain without a warrant, there is no document, right? And if it's the police detaining, I don't know that the police have any forms or anything that they're required to give you. Now, as a matter of policy, typically, if the social worker's detaining, they'll give you your parental rights form and some other forms, might have you sign some releases or some other such nonsense. But I don't know if the police actually need to do anything. Second question is, police detain the child without a warrant. How important is the statement of the child in the detention? How important is the unwillingness to return statement if it's stated by a third party? Let me address the first question first. The statement of the child is always going to be important to the analysis to determine whether or not there was an exigent circumstance. If, for example, the child says, yeah, the minute you leave, my dad's going to beat the crap out of me. Well, yeah, that might go directly to the determination of exigency, right? The axe is falling the moment the officer walks away, the child's going to be injured. He has a reasonable belief that there's going to be damage to the kid the moment he leaves. Yeah, so that would factor into exigency. The child's statement can be very important. How important is the unwillingness to return? And I'm assuming that's the child being unwilling to return home. That's going to be important, again, for the same reason. If the child is so fearful of being injured that they're expressing what appears to be a sincere unwillingness to return home, then, yeah, that might go to support a finding of exigency. But if, on the other hand, the child is clearly just an unruly child, doesn't want to go home because, mom or dad give them consequences for not doing their homework, that sort of thing, that is not a reasonable basis to detain a child. Remember, you cannot detain a child solely based on allegations of emotional abuse. So if the kid is just unhappy because they got their cell phone taken away, or they got an F and her, parents are screaming at her, or some shit like that, and so she's not willing to go home, she's run away because she feels so oppressed by her parents, whatever the case may be, that's not a reasonable basis to detain the child. So in that instance, an unwillingness to return is pretty meaningless. Really, what they have to be looking at are the circumstances surrounding injury to the child. Is there articulable, specific evidence that the child's going to be in immediate danger of suffering severe bodily injury or death in the time it takes to get a warrant? That is the test. So it doesn't really matter if standing alone the child is willing or unwilling to return home, unless there's evidence to show the kid's going to get seriously injured. Then we can take without a warrant. Second or third question, child's appearance, mandatory by law. What if waiver is not stipulated in the MO? I don't know what an MO is. I think it's pretty case specific. Oh, this is James's comment. It's pretty case specific. So yeah, remember when you're sending in your questions, we're not going to give legal advice here. It's educational only, and it's of general application to all viewers. So if you start sending in attachments, you start sending in detention reports, asking specific questions about your case, we're really not going to address those. The next question, is a CFT meeting a legal requirement by law? CFT, they used to be called team decision-making meetings. Now they're called, I think, child family team meetings or something like that. I believe they're required by policy, but I don't really know. That would be a juvie attorney question. I don't do juvie law at all, but that might be something better posed to a juvenile dependency attorney. But I do know that the CFT meetings, I do know, according to training, I can tell you this with County of Los Angeles, if there is time to do either a team decision meeting or a CFT meeting before you take the child, then by definition, there's time to get a warrant. And if they take the child after a CFT without getting a warrant, that's a dead bang winner for your civil rights case. And it's totally 180 degrees contrary to their training and their policy. So next question, is a mandatory settlement conference a legal requirement by law? I have no idea. I have no idea. In the civil context it is, in juvenile dependency, I have no clue. Then the last question, have you ever seen this document? I don't have a copy of the document here. Like I said, if you send attachments and ask case-specific questions, they're probably not going to get answered here. So remember, try to keep your questions general in nature, not specific to the facts of your case, and please do not send any documents. So let me turn now to the inline questions in the chat and see. Fraud upon the court, Lawrence Espinoza. His question is, this is one thing I noticed the other night. Now that the chat strings are gone from the video, I really need to reread the question for the viewers. Otherwise, they have no idea what I'm talking about. So the question from Lawrence Espinoza, does fraud on the court open an avenue? I presume you mean an avenue for liability for your civil rights case. Yeah, it does. That's the fundamental basis, element number one of a judicial deception claim. The idea being that the social worker essentially defrauded the court into ordering the removal, detention, continued detention, or ultimate termination of your rights to the child. So yes, that is the crux of your judicial deception claim, would be fraud upon the court. So let's see. Lawrence Espinoza, whoever originally writes a report never shows up to be cross-examined. Yeah, we have that same issue out here in the juvenile dependency trials. It's always an issue trying to get the social worker on the stand to testify about, what they wrote. I don't have that problem. When I sue you and I hit you with a notice of deposition and you don't show up, you're going to pay my attorney's fees. I'm just going to go to court. I'm going to complain at the judge. He's going to order you to show up, and he's going to order you to pay my $835 an hour for every minute I had to spend to get that order. And if you still don't show up, he's going to pay me more money. Well, you're going to pay me more money. And ultimately, if you still don't show up, he's going to let me enter a default. He'll strike your answer, enter a default, then we'll move for a judgment. So they will show up to my depositions. Let's see what else we have. Think Missa. What would be considered a cutting edge case? Oh, there's all kinds of cutting edge cases. There's the one we just did up in Alameda County, where it was a grandfather-granddaughter situation, and the grandfather statute and run, but on top of that, grandparent rights are really, really difficult. That would actually be a cutting edge case too, if we could get one of those through. But in this instance, it was the granddaughter who, her relationship with her grandfather was impaired by the social worker lies. And he didn't even come on the scene until she'd already been in custody for several years. So that was a very, very curious circumstance. It's up on Patreon, the complaint. It's ES versus County of Alameda. But yeah, that was cutting edge. And we didn't even have the right theory down when we first filed the case. The judge, we got assigned to a different judge. And then I amended the complaint because during discovery, we found that when the girl had been a little child, like 3 years old, they did an unwarranted gynecological exam on her. And so we amended the complaint to allege a violation of her Fourth Amendment rights, and also a Monell claim, of course, for that, because they do that to everybody. And by they, I mean County of Alameda did that to every kid they got their hands on. So, of course, the county, now they get to move to dismiss because it's an amended complaint. They filed a motion to dismiss on our original complaint. And the judge, during oral argument, he didn't really ask me a whole lot of questions. It was all mostly questions of the county. And ultimately, at the end, he sort of teased out this theory that the child had her own independent liberty interest in placement, and that once she started voicing her preferences, the social workers had an obligation to, at minimum, truthfully disclose those preferences to the court and truthfully report to the court all the other related materials, which they obviously did not do. And I'd never seen that before. And so he asked me at the end, it was like an hour-long oral argument, and he didn't really ask me a whole lot of questions to the very end. He just asked me, Mr. McMillan, I understand, I think you've got a case in there somewhere, but if you've been following the discussion, do you think that this is the complaint you want to go with, or do you think you want to amend? And of course, anytime somebody, gives you a softball, you take it. And I said, oh, of course I can amend. So he gave us like 30 days. I scrambled the just massive research, found some obscure case. I don't know, some district out on the East Coast where they came up with this. It wasn't even directly on point. It was actually, I found a treatise and an obscure case to support the proposition that the child has an independent liberty interest in truthful, honest, accurate reporting with respect to placement. And there's no appellate decision on point, but it was good enough. So we made it through on that. We ended up settling the case for really, really pretty good numbers. And, now she's doing well. So the child she's not a child anymore. She's actually aged out. She's an adult, but she's doing really, really well. But that was a cutting edge case. So that's what I mean when I say cutting edge. It's issues of law that are not clear or not yet resolved. Those are particularly interesting. They're difficult. They're challenging. They're very risky, but they're really pretty interesting. Lawrence raised another question. What about when the child wants desperately to go home? Well, that would sort of dovetail into ES, because that was her fundamental claim is, look, I now have met my grandfather. I love my grandfather. He treats me better than my guardian, and I feel more comfortable in his home, and I want to be in his home permanently. That she said that when she was like 7, and then for the next 9 years, the social workers lied, cheated, suppressed, did everything they could to keep her away from her grandfather. And the judge is Judge Chabria, really smart guy up in the Bay Area. He just came out and said, well, McMillan, why don't you try this? I said, well, yeah, I think that's a great idea. Let me go research it and try it. So yes, I would say that if the child is old enough to communicate their desires, then certainly they have to be accurately reported, because the child does have a liberty interest in honest communication with the court. And then secondarily, I think when the it's either 12 or 14, you have to look at, I think it's 42 USC 675. I don't remember which subpart, but when the child turns 14, then the court must consider their preferences. It's no longer discretionary. They must be considered. So if the kid's 14 or older and desperately wants to go home, the court's got to listen, got to think about that at least and consider it. Younger, I think it's discretionary. You're going to have to research that issue. But yeah, it's a potential case, especially now after I've gone through that whole ES rigor. I feel better about those. Another question from Lawrence Espinoza. What is the legal weight of the word concern, and exactly what is it supposed to mean? You know, that's always an issue. I don't know what the legal weight is, but I see it in every frickin' report these people write. It says the agency is concerned that whatever, and then they put some, mean-spirited, fraudulent comment in there to justify taking the kid. But what I can tell you, I don't know legally what weight that carries, but I can tell you that in every deposition, when we're going through their reports and I come across that concern, that's grist for cross-examination, man. What was your concern? Okay, let's go into each facet, each detail, each element. What exactly did you mean? Concerned about what? Why? How? What evidence? All that entire line of questioning. When you see that word concern, you could easily burn half an hour or more of your deposition time grilling. I don't want to use a bad word because YouTube will flag me. Grilling those people on what they meant. What is the rate for someone who isn't an attorney when someone doesn't show to a depo? Well, this is the problem, is if you're doing your own thing pro per, you don't get attorney's fees. You only get, you only get attorney's fees if you're paying an attorney. Or if you're not paying the attorney and it's a contingent arrangement, then the judge will assess what the judge feels is a reasonable attorney's fee. And usually, at least for me, that comes out around $8.35 an hour. That's my current court-approved rate. So I'm always happy if they want to fight about something that I'm going to win on. Come on with it, man. I'll be your Huckleberry. You're going to pay me. Let's see. Kirsten Robinson, have you ever experienced or read about a case where one county DCFS controls what another county does with a sibling's case? Not where they control, but where they have input, and that does happen. And if it were one of my cases, I would sue both counties, both LA and whatever the other county is. So it looks like Ventura, your next question. So I would sue both counties if there's a case there. I mean, I don't know without getting into the facts, and we're not going to do that here. But yeah, you would go after both. So listen, you guys, I'm getting called away for dinner. So I'm going to have to cut it short. I see there's still a few questions. If you guys can email them to capsandstimmslaw@gmail.com, I'll go ahead and address them for you there. For the Patreon subscribers, again, you guys get priority. If you still have questions that were unanswered today, if you can send them over to Patreon, James will get them on the list for tomorrow. And with that, I hope that you guys have a wonderful rest of your Tuesday evening. Stay safe out there, stay warm, and stay dry. I think we're due for some more rain, at least in Southern California. With that, enjoy your evening. I hope you all to see you again.